All right, everybody. Thanks for joining the Winnipeg 420 live stream today. I know it's been a long day, but this is what we've been waiting for. I've got the two best minds regarding cannabis law in this country. I've got John Conroy and Jack Lloyd here with me at Winnipeg 420's live stream to talk everything medical cannabis, everything C45, possession, growing, anything you can imagine. These two are the brains behind the answers. So thank you, gentlemen, for joining me. I really appreciate it. How you guys doing?
I'm great.
I'm the old guy, and he's the young guy.
Hey, pleasure to be here.
I appreciate that, Jack. I really do. Mr. Conroy, how are you doing?
Good, thank you.
Good.
As I say, I'm more of the old guy to do with all the old stuff, and Jack's the new guy who's current on all the new stuff. So,
well, that's precisely why I think you two are the best people to talk to, because I'm sure there are lots of people who have questions out there regarding everything from, like we were kind of talking about before, simple possession charges still, all the way to the C45 proposed medical cannabis guidelines that they're talking about with the consultation period right now, and everything in between regarding, MMAR, constitutionality, and everything like that. So I don't know if you guys have a specific story or something that maybe is fresh in your mind regarding a certain instance you want to talk about, but I specifically have some concerns initially regarding what's going on with this consultation period and medical cannabis grows. I know there's a lot of people out there who are worried about maybe losing access to their gardens again in something like an Allard decision remake or some sort of similarity. But I personally I'm not super worried, but I know people with big plant counts are. And I was just wondering if one of you gentlemen wanted to kind of tackle that first off, and then maybe we can roll with some punches.
well, I can quickly give you my view. Jack, maybe probably a bit more detail. My look at the guidance document, it seemed to me that really all they're saying, with a few tinkering, is really, we've had all these reports of abuse. We've got all these further investigations that say there's been this abuse. And so here's the guidelines that we're going to follow, and more strictly, it looks like, interpret the existing regulations. Looks like they're going to get, into some areas which I question whether they should be able, for example, to get into the issue between the doctor and the patient in terms of the dosage. That's really a personal matter between them. At the same time, what they're saying is that there's some dosages that are huge. I mean, if they have evidence of people abusing the system, such as a doctor, if they've got evidence that the doctor is doing it for a purpose other than strictly medical or whatever, then like any other matter, if they've got the evidence, okay. But I don't. So what they seem to be saying is we're going to be a bit stricter in terms of the factors that exist in the existing regulations. I didn't really see that much that, I mean, as I went through it, I saw things that are in the existing regs that I've always thought they should change. For example, like, other people being able to help a medical person with their grow, as opposed to it being limited to just the individual, although now a DG and the individual can do it. But what's wrong, especially if cannabis is legal, having your family help you with your grow, for example, and to say, there's lots of things like that I think that, they could tinker and make better, as opposed to saying, well, we're going to be more strict and so on.
Right.
But at the other end of the day, you still say their whole basis is their fear of diversion into a so-called black market, and that this somehow affects public health and safety. And that's where you say, well, the whole rationale for your fear and your concern sort of goes out the window. Really, instead of going after people for growing too much, maybe you should allow those people to grow that excess instead of destroying it, to be able to provide it to a nonprofit like the BC Compassion Club Society for medical patients who can't afford to buy it, or
Agreed.
to the BC Cannabis Substitution Project so that they can give it to the homeless who can't afford, to buy the cannabis as a substitute for their opiates. I mean, those are instead of clamping down, there's still this old mentality that is pervasive of, wanting to get tough on people using a stick instead of a carrot. The carrot would be, okay, instead of destroying your excess, you can sell it or donate it under these circumstances to some laudable, positive thing for people who can't afford it.
Right.
And there's lots of little things like that. And so the problem I have is it's always the stick as opposed to the carrot, not realizing that the carrot works way better in terms of getting people to comply. So, I'm concerned. It kind of reads like you almost, I don't know if people have experience with going through the security clearance process, but, it's a similar sort of thing. I can appreciate them saying, look, if you violated the MMAR before, well, that's going to be a problem for you being approved again. It won't necessarily mean you won't be, but so you can understand the standard approach. If you've broken the law, if we find you're abusing, we're going to do this or that.
Right.
So, I think the submissions have to be, why not try a new approach, try a positive approach, try an approach which encourages them. We have this in other areas too, for example, in the dispensary. So you've got the LP sells to in BC, the Liquor Control Board,
Right.
then distributes it to the dispensaries.
Yeah.
And so in the dispensaries, many of them have these little glass things with the bud in it where people can smell and look at the bud.
Right.
Well, I'm told that they have to destroy that too. They can't supply that or put it into the supply. And so you've got a huge amount of these demonstration type things, which presumably, given the number of dispensaries, comes to a fairly large amount. It's simply again being thrown out.
Yeah,
has to be destroyed. Again,
wasteful.
So I guess that raises the whole thing about their fear of what's in it and is it contaminated. And you sort of say, well, where have you been for the last 100 years? People have been doing this regularly without any significant problems. So.
Yeah, we've worked out a system.
Anyway, those are my. And what do we do with other vegetables? Just wash them and clean them, right?
No, agreed. I mean, it's a very interesting scenario when we find ourselves still treating cannabis like such an illicit substance, but yet if I was growing lettuce in my living room, no one would care. But if I'm growing cannabis, it's a federal crime all of a sudden. It's a whole big issue. It is a weird nuance when we think legalization happened, but yet look at all the I guess the strangleholds, the leashes that are still around our necks regarding its use and its consumption.
And often it's funny because the legitimate concerns that they have from, say, growing is stinking out the neighborhood or smelling out the neighborhood, or if you're using a greenhouse, maybe light pollution. And yet, when they come to deal with these problems, here in the Agricultural Land Reserve, they've said, okay, it's a farm use, you can't stop somebody from growing. But at the same time, it has to be either in soil, in a greenhouse, or in a facility that was built before June of 2018. And so you say, well, if a person doesn't have an old facility, you're forcing them to grow in a greenhouse, which could lead to light pollution, or you're forcing them to grow in soil. And certainly a greenhouse and in soil in a greenhouse isn't as easy to control odor and light as it is if you're using a facility, an indoor facility.
100%.
The people in the farming area, we don't want all these big industrial buildings. You say, well, you got barns and chicken ranches all over the place that are even bigger. If you want them to make them look like a barn, fair enough. But you are actually going to encourage people to stink out the neighborhood and cause light pollution if you force them to do it that way. So I don't know sometimes where this comes from, but it still seems to be clearly this attitude and stigma that still is there in terms of the whole issue, unfortunately.
Yeah, and I agree. I mean,
it's been a long time.
Even with growing cannabis outdoors, I mean, in Health Canada's regulations that your license can permit you to grow outdoors. I mean, if you're growing in your backyard, how are you going to mitigate the smell from your neighbors? It's not a real possibility. It's if I have to deal with your, I don't know, lilac bush that really irritates my nose, then you've got to deal with my cannabis plant.
And the whole indoor-outdoor thing, in the guidance, it points out you can't grow indoors and outdoors at the same time. And you say, well, what's the rationale for that?
Yeah.
If you lived here in British Columbia in this north-south valley where we only get X amount of, sun and so on, what you'd obviously want to do is you'd want to start them indoors, your clones or your seedlings or whatever, to a certain stage. You'd then want to put them maybe in a greenhouse if you have them, which can be indoor or outdoor depending upon how constructed the greenhouse is. And you're going to want to have them outdoor. We're going to finish here, unless you're up in one of the hotter parts of BC, you're going to want to bring it back inside to finish it off. So that's going inside and outside at the same time, isn't it?
No, it is. And who's to say, like, where does that definition lie? I mean, what if you put them outside in the morning and you brought them in the house at night? Like, is that indoor or outdoor? So, yeah, I feel like it's very vague.
Cares? Why do they care?
Right.
Well, I think what's really interesting, John, like what you raised with that, what I noticed about Health Canada's document is that they're sort of claiming that this assessment is going under a public health assessment. So what they're saying is look, we're going to look to make sure that there aren't any serious public health issues associated with the issuance of someone's personal use production license. And what's so funny to me about what you've just said, which is, say, a BC grower that is concerned about mold, that wants to bring their plant indoors to prevent mold or something like that, they would deny that under their rules, but they would, which makes it less safe, right? That's actually a health issue, and yet they'd quite happily deny someone's access entirely on that same basis. So I agree with you, and I think they are addicted to prohibition in some ways.
Here in the Fraser Valley Regional District, we've got 8 regions, and 5 of them are supportive, but 3 of them are not. And so you've got this bylaw that applies to the whole regional district, where they're encouraging people in the other parts of the valley and discouraging people, even though the Agricultural Land Commission has said it's a farm use, you can't prohibit it. And so then they'll, of course, they've abdicated their responsibility to local government that then can control you with building permits and all all that stuff that really make it very difficult for you to do it.
That is something I think about all the time, John. In Stephen's story, I'm always hijacking people on this.
I love it.
What the federal legislation that's always been a problem to me, that they delegated authority to local government for the suitability of these, of someone's ability to grow. And I've always thought to myself that's like a really serious problem, because you end up with all of these zany local rules and regulations that effectively result in a total prohibition on personal use production licenses. Like, what are your thoughts on, like, I hate being the person that says I don't like local government, but in some circumstances, I really do not like local government.
Jack, you're 100% on the ball here, because I was just going to touch on this. This is a great question. John, what are your thoughts on that? Because a lot of people
it's a very difficult issue, because, in a democracy and in a federal country, you have the federal government, the provincial governments, regional districts, and local governments like cities, municipalities, and so on. And inevitably, local government is going to be concerned about local zoning, planning, licensing, permits. They always have been for all the businesses and so on.
Right.
So, and there is a safety concern to some extent. I mean, not everybody, as we know, is reasonable, rational, and logical in terms of the things they do. And even if, there were lots of people in the old days taking all kinds of shortcuts in their apartments and stuff, which could put the whole apartment at risk.
Agreed.
Or certainly stink out the whole apartment and stuff like that. And so, on the one hand, I accept as a lawyer that you've got to comply with local government, and that makes it safer and you're in the right zone. But I mean, there's always that distinction between commercial and personal. And so this is where I think we ran into some of the problems with them trying to be overly regulatory in terms of the personal as opposed to the commercial. But even in the personal, if you're in a strata title place where, everybody gets to vote whether you can do this or not in your strata, or if you're in a small apartment and so on, these issues do arise. Now, we established in Allard that that's not a reason to prohibit, that these issues are what we call mitigatable. You can do things to make sure there aren't fires, like get an inspection. You can do things to make sure that you're not going to affect your neighbors by, doing things to make sure it doesn't escape, and so on and so forth. So it's important for people to do that. But again, I come back to the carrot and stick thing, and I say, so owners of apartments, why don't you expressly create an area in the basement where your cars are parked, or a separate unit on the grounds next to the apartment or something, and say to everybody, look, if you're approved, here's a place where you can do it. Or why don't we allow for grows, so that a person who's in that situation, who can't grow in his strata or who can't grow in his apartment, is able to go to a U-grow where there's a person who looks after maybe 8 or 10 grows, where the patient or the DG or whatever comes there to do stuff, but there's it's just like a U-brew making your own beer.
That's a brilliant idea.
Why, so again, it's a carrot. It's here's a good way, guys. Instead of prohibit, stop, and people going underground and doing things that could put everybody at risk, here's a practical solution that's in everybody's interest and we can all agree to and work towards. But,
I feel like practical solutions aren't the best quality for the government.
John, what are your thoughts, John, about the ban on personal cultivation in Manitoba?
Oh,
that's
what
plants. Stephen. There's a prohibition in Manitoba on that issue, and it just makes it so palpably clear to me that there's this almost this bifurcation of the issue between federal and provincial governments.
And to touch
I understand. I spoke to Jesse Lavoie briefly about it, but I was his lawyer. I said for his lawyer to call me if I can assist. But what's the basis for the denial? Does a federal law allow them to? Does it sort of leave it up to each province to decide whether to allow that or not?
It really doesn't. Right now the provincial government is using the same arguments that the Crown used in Allard. The fire and mold, the health risk. They're using all that as their evidence, and I'm sitting here going, like, you guys already lost this battle on a federal level regarding our medical gardens. It's not going to apply to this, but they're choosing to fight it. And Quebec already ruled it's unconstitutional. So as soon as that, I don't know.
Yeah, so that's what I'm thinking. I mean, if it's medical, the feds have kept control over medical. The provinces don't have any jurisdiction over medical. We've managed to keep the safety unit, so-called Cannabis Safety Unit or whatever it's called.
Yeah.
That goes around trying to enforce dispensary rules. We've managed to keep them off the backs of the BC Compassion Club and the Cannabis Substitution Project, saying they're strictly medical. They're applying for medical licenses, nothing else. This is not a storefront trying to sell stuff to everybody or anything. It's solely trying to supply medical patients who got a medical problem. And so, we would say, what jurisdiction does the province have? Now, but we are talking about 4 plants that a person can grow of any size and store as much as they want and possess up to 30 grams when they're out and about. And so Manitoba is saying you can't grow the 4 plants or store the results, but are they stopping you from 30 grams when you're out and about?
No, you can still have possession.
So you can possess 30 grams, but you can't supply yourself, but they have licensed producers there that you can buy from a licensed producer. So the prohibition is on growing your 4 plants for yourself and storing for yourself.
Correct.
Yeah.
Yeah.
See, I didn't think there was anything that, if the feds are allowing you to do that, certainly for medical purposes, I wouldn't think that they could interfere with that at all.
No, they aren't. They won't.
Can they interfere with the 4 plants for rec?
Yeah.
So, I would have thought they could limit it maybe by saying, look, not in a small space or something like that, and offer the carrot.
That's the arbitrary thing I think they might do, is that they might end up just saying, okay, sure, you can grow 4 plants, but putting some, height limit in or something like that, that makes it, an undesirable option for people. You know what I'm saying? Like provincial regulations could really make this a pain.
Careful about the height limit. They had that height limit in there in the beginning, and we all laughed about how.
Oh, I know. That's why I remember.
From Friday to Monday, it might suddenly go over. I could see the police coming with tape measures.
Yep.
I mean, it's. I don't understand how the province. I mean, do they have legislation that they actually banned it with legislation?
Yeah, they did.
And it's similar to Quebec?
Yes, exactly similar. And the arguments are almost the same. So I feel that the Quebec decision already being ruled is unconstitutional, even though it's been challenged or appealed, but it hasn't moved anywhere. So as soon as that's dealt with, I assumed it would make sense for that it would be unconstitutional in Manitoba after that. But
it's highly persuasive. It's not binding on your Manitoba courts under the law. Okay. It's a highly persuasive decision, and I don't know if have you had a chance to look at it, Jack, the Quebec one?
Yeah, I reviewed the Quebec ruling, and then I've reviewed just Mr. Lavoie, the Manitoba plaintiff's materials, and it's a division of powers issue. That basically they're basically creating a criminal law.
Yeah.
Well, yeah, because the feds have said this is still criminal law, and it rather obviously is still criminal law with all the offenses and penalties that are still there. I mean, I raise that, but every time I do, I want people to understand that, way back in the 60s, when suddenly white middle-class kids got interested in cannabis and all sorts of people were getting busted, they hybridized the Narcotic Control Act in many aspects so that the police or the Crown could proceed summarily like a misdemeanor or by indictment like a felony. Okay. And before it was always a felony, and even with mandatory minimum. So they've done that again in the Cannabis Act. And so people have to understand that really it's a historical move in the right direction to give the option to go the less serious way as opposed to the more serious way. It's another slow, plodding political way of trying to make it more acceptable over the years. So, but it's still, there's summary conviction and indictable offenses with simply some exceptions made for the 30 grams and so on, and these delegation of distribution to the provinces. But so, originally I thought, well, on a federal division of powers, you'd have the feds controlling production, like with tobacco or booze, but the provinces control distribution. And so, it was under property and civil rights and other types of heads of power, as opposed to criminal law. But the Fed said, no, this is still criminal law. We're simply allowing the provinces to do the distribution. So, yeah, and I assume Quebec found it to be still criminal law, did they, Jack?
That's my reading of it, yeah.
So what stage is it at in Manitoba then? It's gone to, has there been a trial level hearing?
I don't believe it's gotten to that point. Well, the last thing I know from Jesse, he told me that the province has decided not to present evidence. He presented all his evidence, and they've decided not to present any of theirs, which I don't know what that means really. That doesn't make any sense to me. That makes me think that they're just going to stall it out.
Because all of the evidence to do with mitigating harm from fires and all that stuff is in the Allard transcripts.
Right.
They're all available on my webpage, in fact.
I know, it's like a cut and paste, and this is the argument.
if they put that evidence in and it's uncontradicted, I don't see how the government then makes their case.
I honestly don't think the government will make their case. I really think I've spent many a year fighting the provincial government here in Manitoba on everything from, vaping indoors as a medical patient towards consumption in public, everything in between. And I've noticed that the government here does not like to do anything progressive until they're forced to. Okay. And I think that's where we're at, is that I really think they're going to drag out this case as long as they can. And they're going to probably end up letting the Quebec decision happen out of the appeal, and then maybe be like, oh, okay, well, now that it's kind of on us to make the right decision, we will, but that's just prairie slowness.
Forced kicking and screaming.
Yeah.
Well, it's not just Manitoba.
Tell me.
Other places.
Actually, sorry.
I've always said, in my dealings with the government, a court order has always been far more effective than trying to talk them into doing things.
Yeah. A Supreme Court decision always has a little bit of gravitas when you want to get your way. Jack, actually, I had a question for you. And this is more of the like Mr. Conroy was saying, more of the new kind of rules and regulations. What are your thoughts regarding the pardons for simple possession? And do you think that will ever extend to, simple cultivation and or trafficking charges eventually?
That would be my fantasy for it to extend. So certainly, I've had a desire to challenge that. John is actually kind of the core litigator on that in a case in Manitoba called Neary, which is a fantastic trial decision and a horrible Court of Appeal decision. But Stephen, I do believe that it's coming. And I think that it's going to be a specialized application process if we can force them to do it using a litigation strategy that John created in Neary. So essentially a challenge to the validity of certain long-term punitive strategies by the federal government. So I do think that it's going to be something that we force them to acknowledge through litigation, but it's going to take time. But the part of the issue for me that I deal with kind of regularly in my practice is that I don't prefer a pardon to a discharge. If I can get a discharge, I am not interested in a pardon, because and John wrote an incredible article about this about 5 years ago. John, do you remember that article about the ghost charges that show up in the system? The
prejudicial consequences of a non-conviction. Yeah, I actually wrote that about 10 years ago, although I had to update it a few times. But that was to do with stays of proceedings.
Yeah.
And how, everybody's happy. The lawyer says to you, oh, the Crown's going to drop the charges. They're going to stay the proceedings. When I started practicing in the early days, if the Crown was not going to proceed and not call any evidence, and they were going to drop the charges, we would come to court, stand there, they'd call the case, they'd say they're not calling any evidence, and we'd invite the court to dismiss the charge. So your record would show dismissal, not guilty. no conviction, a stay, they then figured out they didn't have to go in front of the judge. They could just enter a stay, because the provision in the code says, that they can basically enter a stay of proceedings at any time. And if they don't revive those proceedings within set time periods, the maximum being 1 year, then the proceedings are deemed never to have been commenced. So they shouldn't even exist. And yet they keep a record of all these stays. You go to the border, they say, oh, it's a stay of proceedings. It could be revived. You go to prison, the parole board cross-examines you on the stay. What were all those things about? The people in the corrections, they write in your paperwork, oh, he has an escalating criminal history. Look at all these stays of proceedings. Oftentimes the Crown charges you with 5 things in order to get you to plead to one, and the other 4 are all related to the one. So the stays are irrelevant. There's only one basic offense. Or sometimes they stay because they don't have the evidence. And so you say, well, it's an accusation. It's not a conviction. How come you're even questioning him about it? So there's this whole problem, and it's gone beyond that now to the digital database. If you do any of these security clearance work, you'll see, 10 years ago, you were seen at a beach in Vancouver with a bunch of your friends standing around a car, and somebody complained about the smell of cannabis, and the police arrived and they took all your names down and they said, hey guys, move along, people are complaining. Nobody got charged. Nobody, but we think you're going to divert into the black market, that your conduct is such that, you're a risk to public safety. I mean, these are real fact patterns that we see arising out of digital databases, because before it would be in some notebook and you may not ever see the note. Yeah. So now they just pull it up on the computer and it's used against you. So I don't like and I deal with pardons on behalf of prisoners with other offenses. In a pardon, you have to apply for the pardon. You have to wait such a period of time before you can apply for it. You then apply for it, and there's this. The minister at the end of the day decides whether to grant you the pardon or not. And if you screw up, they can revoke the pardon. So pardon is good for the person who goes through the prison, does this whole thing and shows, and then ultimately gets a pardon. It's not going to let you into the U.S., by the way, because they'll say, oh, they'll still have a record.
Yeah, you got to find a way.
They don't recognize they don't recognize our records. Expungement is the word. That's what they've just done in California. That's what they're doing in New York. It's about especially simple possession. They should be expunged.
Right.
Now,
just written
the feds will say the problem is, how do we figure out? Because all that the record will show is simple possession of a narcotic or of a controlled drug, not necessarily show that it's cannabis. So it'll be but they find it easy enough to find your record when they want to present it in court and so on. So surely they should be able in their database to find all the people who have simple possession records, wipe them out.
Yeah.
Production, cultivation, as it was called in the old days, possession for the purpose of trafficking. Well, okay, those are a little more difficult, but they should be able to look at the circumstances, because that could include a huge big time dealer to a tiny one joint dealer, within those definitions. So, ultimately we want to get to the stage where they don't really care about even the guy who in the old days was a big time dealer, because it's not worth their while. There's no, so what if they're now involved in the legal business? Just because they were bad in the past doesn't mean they're going to be bad if you license them.
Exactly.
Now, one of the things that they keep failing to address, it seems to me, is that they are entitled to mitigate the risks by imposing conditions. So you got a guy who's associated with maybe one of the top crime bosses and, over the years, 10 years ago, and they think he's all connected and so on, but he hasn't had any convictions in the last 10 years. He's had a steady job. Why should he be prejudiced? They can easily simply say, And this is we're issuing you the license on the condition you not associate with that person.
Right.
And if you do, you jeopardize your license. The parole boards do these things all day, imposing conditions to limit and manage risk and so on. I haven't seen them impose any conditions here. They simply say, oh, you're a risk, and that's it. So again, the whole approach, we're legalizing. I mean, it seems to me the error was doing it the way they're doing it instead of rolling everybody in and saying, but we are going to look at your circumstances and we may bring in some modifications and we may put some more conditions on your license and so on and so forth in order to get this legalization happening.
No, I hear you. There's a lot of hurdles regarding records in the industry right now. It's a lot of it's arbitrary. So I mean, it makes no sense.
It's and we got to remember when we sentence people, there's a deterring factor, but there's also a reformation and rehabilitation factor. And after the way we structure our sentences, in federal sentences anyway, is the first third is the, deterrent part. And then the second third or 2/3, the whole idea is to start working on your reformation rehabilitation, helping you reintegrate as a law-abiding citizen.
Yeah.
Well, if just because you've got a record or you've been to prison, you're going to get blocked from all sorts of things in the future, that's inconsistent with trying to, help the person become legal.
I agree. And that goes for anything, I think, really, though. I mean, any record that's being punitively put on you long term as a criminal record that hinders you from getting a job or housing or anything like that, I think it's just it's a cruel and unusual as far as I'm concerned. But that is such a great conversation here. I have a question regarding someone. I kind of put it on social media earlier. People had some questions, and I'm not really sure where this question lies, but people had some questions regarding the CDSA and how that applies to the Cannabis Act regarding like medical cannabis grows. I'm not really sure. Something about the Wolseley decision. Are you familiar with that?
The what decision?
The Wolseley case? I'm not quite sure what they was referencing, so I'm just trying to throw these out there to see if you guys had any ideas.
The CDSA doesn't apply to cannabis at all anymore. That it used to be Schedule 2, and it's gone.
Okay,
so
good.
Cannabis is Cannabis Act and regs.
Right. So
all anything to do with cannabis is Cannabis Act and regs.
Excellent. This is great to know because I love clarifying stuff like this for people who are watching.
Yeah, and I mean, the regulations, the MMAR used to be under the CDSA, the ACMPR, which was the merger of the MMPR and the MMAR.
Yeah.
Remember, MMAR was first, then Harper with the MMPR. Then the court decision forced them to create the ACMPR, which was really the merger of the two.
Right.
And now you have the ACMPR that's part 14 of the Cannabis Act regulations. It's also called the ACMPR. And it's the old ACMPR with a little bit of tinkering.
Yeah.
So and that's medical and that's federal. There are no licensed medical compassion clubs. The BC Club has an application pending. I think Ted Smith on the island, the Vancouver Victoria Biosh Club has an application pending.
Oh.
And the Cannabis Substitution Project, we have an application for an exemption from the law to enable them to keep supplying cannabis to homeless opiate addicts in the downtown east side.
Oh, that's amazing.
We're saying there should be licensed dispensaries that are solely medical, that are not rec. And of course, the sense is that the feds would like to see medical disappear into the rec because everybody can just get it from the rec. But a lot of these folks can't afford the rec prices. And the rec prices are fixed to some extent by whatever the LPs sell to the LCB, and the LCB does something in there, and the dispensaries' hands are tied to some extent in terms of what they can or can't do in terms of their prices, I understand. So, again, a problem for the poor or those who have difficulty with those types of prices.
I was under the assumption that there had been 2 stores, maybe Jack, you know this one, but that 2 standalone medical cannabis sales were in Ontario now. I was under that assumption from another legal mind I know.
So there's a pharmacy that has received a sales license that's in the process of setting out a situation very similar to what John has done for the application for the BC Compassion Club Society. So they've received that license.
Is that Shoppers? Is that Shoppers?
No. So Shoppers does not imagine a person being able to attend at the storefront to access. Shoppers is all through the mail.
Yeah, the online stuff, yeah.
So a lot of the innovation in that space is happening with just people that have a pharmacy and say, okay, I'll apply for this sales license and see what happens.
Makes sense.
That's a really neat idea. I mean, I love that there is at least, I mean, and you two are, again, are the best people to talk to about this, is that making the laws work for what you need, right? And not just being a victim to those laws, right? So it's this is really neat. I mean, I'm very curious to see how those exemptions go regarding, like the downtown east side regarding the opioids and things like that, because that seems like if that gets allowed, then it makes me at least hopeful for the future that there is progression coming.
Well, what I think we need to do, well, Jack will see the hurdles, is there's something called a national formulary. And then there's provincial formularies. And there's even correctional institution formularies. And so you got to get the drug on the formulary so that people who are being prescribed opiates that get paid for under the medical plan will be able to go to their doctors and get cannabis paid for under the medical plan instead of the opiate. We have the National Academy of Science, Engineering, and Medicine in the U.S. several years ago, looking at all of the studies and everything to do with cannabis and medical, and saying that despite all the problems doing the research, there is overwhelming conclusive evidence of the effectiveness of cannabis for chronic pain. Many of the people getting opiate prescriptions get them for chronic pain. If they could have cannabis paid for, they would ask for cannabis from their doctor. A bit of educating of doctors still required, although it's getting better and better as time goes by. There's now a good international group that's expanding considerably in terms of doctors supporting. I mean, I think, again, it should be put on the national formulary, maybe as a natural healthcare product, which it really is, as opposed to a drug.
Right.
It fits the definitions of all the natural healthcare product regs, so that naturopaths and doctors of traditional Chinese medicine, as well as regular physicians, can be the ones who approve you and get paid on the medical plan for doing so. This would substantially, it wouldn't eliminate the opiate crisis, but it would help contribute towards reduction of people using opiates and therefore becoming addicted to opiates, and they would be substituting something that has no lethal dose that addresses their pain.
Right.
And so, if we can get it on the national formulary, from there, I think you have a fight to get it on the provincial formulary.
I'm actually fighting that right now in Manitoba. Safety
and efficacy is the test. Well, if you can go to a store and buy it when you're over 19,
right?
Surely that addresses the safety issue.
Well,
the efficacy thing, well, I mentioned the National Academy. There seems to be tons of stuff coming out about the reduction in opiate consumption with the existence of dispensaries and the availability of cannabis throughout the United States. There's over 20,000 studies on PubMed that have bigger, groups, cohorts than the studies done by the pharmaceutical industry.
Agreed.
That show that this is effective and it's safe. So we need to do that. I mean, in the old days in Matsky Institution, when I was a young lawyer, they used to say to them, don't smoke the stuff keep it out of the way. We don't want the visitors and everybody to see you smoking cannabis. Right. Until finally, I think it was Reagan reintroduced the war on drugs and everything became bad again. But they used to try to lie to people consuming cannabis in the institutions in the old days. and the guards didn't mind. It kept everybody calm and happy instead of getting into booze, you know?
No, I have a question actually regarding
So
that.
I don't know. We just gotta.
No, oh, go ahead. I was just saying, like, there needs to be. I know that we're on this topic that there's always been the question is why, cannabis doesn't have a DIN, a drug identification number, regarding insurance coverage and things like that. And I think that I don't think we'll ever see a DIN for like dried flower, but I think that with these oils and these
capsules.
Right. These ability to actually give a proper dosage amount that you can maybe get a DIN, maybe get some coverage.
They do have Epidiolex and a couple of others. GW Pharmaceuticals, I know, made a couple that are whole plant medicine.
Right.
The
Wasn't it like
original
Marinol
one,
or something like that?
Old days. Marinol was synthetic and was produced by a big pharmaceutical industry in France, I believe. Gross. But so that does exist. The movement from plant in different forms into capsules and so on. But I mean, you say, it should be the doctors in Allard, in Parker, and so on, were approving their patients for the use, which was inconsistent with the prohibition, which was designed to protect health. And yet they still keep requiring these double-blind, placebo-based studies in order to go through the process. When we've got royal commissions going back to 1894 that said this stuff wasn't risky. And so with all of those studies, and now, as I say, with it being available if you're 19 to go and buy it, surely the safety issue for people over 19 is and the efficacy issue, you can debate that till you're blue in the face, but there's lots of evidence to support that it is effective. So let's get on with it. Let's get people off these opiates. We got more people dying here from opiate overdoses than COVID. So, I don't get it.
No, that's a very real statement, actually, that, the opioid crisis is a huge problem, that they don't seem to be doing any, real effort. I mean, if we could replace opioids with cannabis, done. Seems very logical.
The fear of cannabis is so hard to understand.
I think unless you're really submersed in it, and especially from you folks with the legal side and how it's actually applied to people still, it can be very... I guess sobering is an ironic pun to realize how tough this industry still is.
I grew up in Africa. My father was a consultant on the growing of tobacco. If he walked through the tobacco fields, he would see a cannabis plant, he'd pull it up and throw it on the ground. I could walk down paths on my way to this place or that, and I might see some African people smoking and consuming, which I would be told was gacha, which is the word for cannabis.
Okay.
Nobody cared any more than that. It wasn't until I came back to Canada, in fact, many years later, after finally becoming a lawyer, that I saw people going to jail for this stuff. I just couldn't figure that out. But you would have, no problem at all and of any sort. And all of a sudden, here you are 20, 30 years later, and there's all this fuss.
That's such a reality check.
Crazy.
Yeah, we've really torn it down here in the Western society regarding acceptance of stuff. I hate to cut our audience short here, but I know we're running close to our hour mark. I wanted to give you guys both an opportunity, maybe if there's a way people could maybe reach out to you if they need to in the future regarding possibilities of legal challenges they might have, or any maybe just if you're open towards the consultations regarding any sort of challenges or anything like that. How can folks get a hold of you guys? Is it just through social media, or John, you want to go first?
The worst thing to do with an old guy like me is all the different, I can't keep track of where all the messages come from on Messenger or on that green or the yellow, this is the green with the white thing. I'm really showing my age now.
No, I love it, man. I love it.
I got used to email.
Excellent.
Email is always best for me because that way I can put it in a file and keep track of it. I'm still trying to push the button to forward other things to my email, and sometimes they show up and sometimes they don't. And so,
I know that story.
So email is best. I'm semi-retired. I'm sort of winding down my practice, trying to, because I do prison work, because I'm surrounded by prisons. I still have a few prison cases that I'm trying to finish off. So I'm basically trying to refer most of the stuff to Jack.
Oh, okay.
And we've got other young lawyers who were involved with us in Allard, Matthew Jackson and Bibas Vaze and Tanya Grace's firm. So we've got the group of lawyers that was involved. And so when people contact me, I usually send to them to see if they're interested or if it fits into one of the other things that's going on, and, you know, try to assist in that capacity. But I'm not, and interestingly enough, like the question we got earlier before we started, somebody wanted to know about the class action. It's amazing. Out of the blue, I'll get these questions about the class action. What's going on with the class action? And, you know, I have to say, oh, you're talking about the privacy breach where Health Canada breached people's privacy.
Nailed. Yeah.
And, you know, I don't have anything to do with that, nor does Jack, directly anyway.
Yeah.
Branch McMaster, these big class action firms are the ones doing it. In BC, it's Branch McMaster. And it is confusing. I find these class actions, they go on forever and ever and ever. Whereas a constitutional challenge like we did in Allard, we can get done quickly. The class actions, because there's so many people in the class, the government ends up with every objection. It goes on forever, and it may even be settled, and then you've got all the bureaucracy, you know, slowly, very, very slowly administering to try. I mean, I've got Aboriginal clients who were part of the 60s Snoop class action who have yet to get money, that some have got it and some don't. So it's very confusing. So I say, call Branch McMaster and bug them, find out who, you know, is dealing with it there.
Right.
The lawyer who used to be doing it, I don't think is on it anymore. There's another person. I think that's, unless, you know, and I think that's the only class action that's cannabis class action that I know of. There's a whole bunch of prison class actions going on, as far as I know.
But if anyone wants to talk to John or I, they can just call our office, 604-852-5110. Or johnconroy.com is John's website. And that's
send us
fine.
emails, or Danielle contact us, and then I try to get it to one of the guys that move with it.
Awesome. I honestly think this might be the most informative, kind of cogent conversation that the cannabis community has been exposed to for a little while. So thank you, gentlemen. This has been extremely insightful for not only myself, but I'm sure everybody watching.
Happy 420.
Thanks for having us.
Thank you, Jack. Happy 420.
Thank you.
Happy 420 to you too, John.
Happy 420, and I hope it warms up in Winnipeg.
Thank you, buddy. I really appreciate that. I'm so glad to have, like I said in the beginning, some of the two best minds in this country regarding cannabis law. Thank you so much, gentlemen, for joining Winnipeg 420 today. I am forever grateful.
Best of luck in the court case.
Thanks.
Cheers.